So first up, on the arbitration front, we have Wells Fargo Bank versus Agak. This is a May 2021 case. These are all recent cases in 2021. This is an appeal of a relatively rare denial of a petition to compel arbitration. The interesting thing about this case is there are not one, but two opinions. The majority, authored by presiding Justice Gilbert, and then Justice Tangeman, authoring a dissenting opinion. Now, after you read Justice Gilbert's opinion, you'll probably agree with it. And the gist of it is that by having waited 7 months before moving to compel arbitration, the majority found that the bank waited simply too long and had waived its right to arbitration. But I think when you read Justice Tangeman's dissent, you'll probably change your mind.
You were right about one thing. I did read both the majority and dissent opinion, and you know, California opinion is always a surprise when you get a dissent in state court.
Right.
And at first, I absolutely agreed with the majority, and then I absolutely agreed with the dissent. But on balance, I agreed with the dissent's position. It was really compelling that the bank had a contractual prohibition against initiating an arbitration, and that didn't seem to factor at all in the majority's decision.
Yeah, I came to the same conclusion you did. What happened in the Agak case was that the debtor had raised the debtor is the defendant, raised new claims later on in the suit. So while the bank did happily litigate for many months, that was because the bank did not even have the right to arbitrate the claims that were earlier pled in the case. But when different claims were raised, the bank did have the right to arbitrate those and then moved to compel them. But the Court of Appeal nonetheless held that the bank had waived that right.
Yeah, you know, and an interesting wrinkle here is that the decision relied on statements made within the party's CMC statements, and the fact that the bank's CMC statement did not mention arbitration. So the case suggests that it might be a good idea to include some protective language in your CMC statements to the effect that you are reserving all rights to arbitrate. And more broadly, be careful what you put in and omit from CMC statements, because some appellate court may hold it against you at some point.